So when we talk about reasonable accommodation of disabilities, it's one of only two areas in employment law where there is a reasonable accommodation obligation. The other is when it comes to religious observances, for example, giving people time off from work on the Sabbath, that type of thing. We see issues regarding reasonable accommodation of disabilities much, much more frequently than we see issues regarding reasonable accommodation of religion. In New Jersey, disability for purposes of the anti-discrimination law is defined very broadly. It can be any physical, mental, or emotional condition that is diagnosable, regardless of whether it's permanent or temporary, regardless of whether it's severe or relatively minor. The law requires that once an employer knows an employee has a medical issue that somehow impacts their ability to perform their job, the employer has an affirmative obligation to provide reasonable accommodations. So what's reasonable in this context? Well, let's talk about what an accommodation is first. An accommodation is a change. It's a change in the job duties, a change in the work schedule, some sort of change in the terms and conditions of employment to allow the employee with a disability to do their job. It could be temporary, it could be permanent. Reasonable means that the employee is able to do the essential functions of their job. An unreasonable accommodation is one that would let the employee not do the essential functions of their job. And so the easiest example, the one I use with clients most often, is when you talk about somebody who works for a construction company as a ditch digger. If that person develops a herniated disc or spinal stenosis or arthritis in the lower back and can no longer dig ditches, giving the person the opportunity not to dig ditches is not a reasonable accommodation because that's the job. However, if there's another open position at the company that the person is qualified to do, the employer could be required to give that person that open position. They're not required to bump another person out of their job for the employee with a disability, but if the position is open and the employee is qualified, they would be required to give it to them. Reasonable also has another meaning in terms of what burden it imposes on the employer. The employer can assert what's called an affirmative defense, where they have the burden of proof to show that the accommodation that the employee requested, and for that matter, any accommodation that would allow the employee to do the essential functions of the job, is an undue burden on the employer. And so an undue burden could be financially. Most commonly, you'll see that in cases of serious physical disabilities that require architectural accommodations, that require the employer to actually physically change the physical workspace in some very dramatic and expensive way. But it could also be an undue burden for the employer operationally. Often we're looking at how many employees do the same job as that employee who needs an accommodation. And this is in the context where the accommodation the employee needs is time off from work to heal from something. And if you take the opposite ends of the spectrum, if you have an employee who is the only person at the business who does that work, so for example, the CEO, they're not going to be able to accommodate the CEO being out of work for medical reasons very long, because he's the only person or she's the only person who does that job. At the other end of the spectrum, and this is not to look down upon people who are at the other end of the spectrum, but if you're in a position where there's a lot of people at your employer who do that job, like a secretary, for example, or if you're in a position like a secretary where it's easy to go to what we call a temporary agency and get a temporary replacement, it's much easier to hold the person's position open for a long period of time while they heal, because there's other people who can cover the work. And so the employer can argue it's an undue burden for us to hold the position open because, we don't have anybody to cover your job.